Welcome, everyone. Thank you for listening to the Council of Institutional Investors, Voice of Corporate Governance. I'm Jeff Mahoney, General Counsel of CII. Our topic for this episode of the Voice of Corporate Governance is the economic cost to investors of Delaware Senate Bill 21, which was approved by the Delaware legislature and signed into law on March 25th, 2025 by Delaware Governor Matt Meyer. And my special guest to discuss our topic is Roberto Tallarita, Assistant Professor of Law at Harvard Law School. Professor Tallarita is the co-author of a recent research paper entitled The Price of Delaware Corporate Law Reform. Welcome, Professor. Thanks for taking the time to speak with us today.
Well, thank you. It's great to be here.
Professor, let's begin by providing our listeners with some background and an overview of Delaware Senate Bill 21.
So the very short answer is that SB 21, as the bill is commonly referred to, made it more difficult for shareholders to challenge transactions with controlling shareholders, and to some extent, conflicted transactions in general. So under the old rules, which were judge-made rules mostly, controller transactions were subject to fairness review by the court, which is a pretty strict standard, unless the transaction was approved both by a fully empowered committee of independent directors and a majority of informed minority shareholders. Only if the company followed the strict process, the court would apply the much more lenient business judgment rule, which means that the transaction was essentially always upheld. With the new rules, however, for many controller transactions, only one of these two mechanisms is required. Essentially, there is no need anymore for a majority of minority approval for many controller transactions. Independent directors can approve these transactions with little risk of shareholder litigation. Another important change is the statutory definition of controlling shareholder. Shareholders with a significant minority stake, but less than 1/3 of voting power, may not be considered controlling shareholders anymore. This is what happened to Elon Musk in the recent challenge to his $56 billion compensation package at Tesla. Musk owns around, 20%, 22% of Tesla, but the Court of Chancery in Delaware found that he nevertheless was a controlling shareholder of Tesla. Now the statute says that this cannot happen anymore. There's some controversy, like some interpretive question about what the statute really says. It's badly written. Everyone agrees on that. And some scholars believe that the common law definition used in the Elon Musk case survives the new language of the statute. We'll see what the courts think, but it's pretty clear that the goal of the Delaware legislature was to exclude situations like Elon Musk's from the definition of controlling shareholder. And another important change I want to mention, which is important for shareholder litigation, concerns the inspection rights of shareholders. Under Delaware law, shareholders can ask the company to take a look at certain corporate documents as a way to gather information useful for a lawsuit. And the statute narrows the scope of these rights, makes it more difficult for plaintiff lawyers representing shareholders to get access to those documents. So the combination of these main changes and other minor changes I didn't mention raises the bar for plaintiff lawyers representing shareholders in a lawsuit challenging a conflicted transaction.
Professor, as you indicated, both the process and substance of SB 21 have attracted significant controversy. Can you tell us why?
Well, on the substance, it's pretty clear. People have different views on the role of shareholder litigation in corporate governance. Critics of SB 21 think that the new rules allow controlling shareholders and conflicted managers to extract too much value from shareholders and get away with it. Supporters of SB 21 think that today there's too much litigation, often of little value for shareholders, and the new rules are a good compromise between curbing excessive litigation and keeping important safeguards in place. So there's disagreement about what the right policy is. On the process, the main critique has been that the Delaware legislature and the governor gave in to the pressure of powerful founders and other corporate insiders to loosen up the rules with little or no regard to what is good for investors or what investors think. The bill was proposed and approved in the span of a few weeks with very little debate and no room for compromise, basically. If your listeners want to take a look at how the debate unfolded, they can watch the video of a session. It's online on the Delaware Legislature website of a session of the Delaware House of Representatives. Professor Robert Jackson, professor of corporate law at NYU and a former SEC commissioner and full disclosure friend, a co-author of mine, was thrown out of the meeting in a quite aggressive way while he was trying to explain his point of view on the bill, a very knowledgeable point of view given his background. So the process did not look very good for Delaware, I must say. However, some people disagree on this as well. They think that what happened actually shows that Delaware is able to act quickly and effectively to correct what was perceived to be as an unbalanced situation between plaintiff lawyers and corporate boards.
Professor, another controversial aspect of SB 21 is that the bill includes a provision that, in your words, instructed the courts to raise the bar for proving that a director is not independent. So can you describe that provision and why it's controversial?
So the new statute says that if the board believes that a director meets the stock exchange definition of independent director, there is a presumption of independence for that director. It means basically that if the board thinks that the director is independent, the plaintiff must do much more work to rebut this presumption and prove that the director was, in fact, not independent. So the statute says that the plaintiff must show substantial and particularized facts. So essentially, it's a way to say to the judge, look, you're being too friendly to the plaintiffs recently. Plaintiffs need to bring much stronger evidence before you can rule that a director is not independent. So once again, this is a way to try to make shareholder litigation more difficult and to reduce this kind of lawsuits overall.
Professor, your research paper provides empirical evidence on whether SB 21 was good for investors. So how did you conduct your research and what were your key findings?
So the key point here is that it is an empirical question whether the bill is overall good or bad for investors. As I said, there are both critics and supporters of the bill, and they have potentially good arguments, both groups. Excessive litigation is bad. Extraction of private value by controlling shareholders is bad. So in theory, this can go both ways. It's not clear whether the overall effect of the bill was good or bad. Answering this question is an empirical exercise, which is really hard, of course. But what we can do, and what we did in this paper, is to try to measure how investors reacted to the news of SB 21. If critics are right, we should expect stock returns of the companies affected by the new rules to react negatively. If critics are wrong and SB 21 is actually good for investors, we should see a positive reaction, or at the very least, no reaction at all. So what we do in this paper with my co-author, Professor Kenneth Koo of the National University of Singapore, we run a series of event studies to try to measure the stock market reaction to SB 21. So in a nutshell, we compare the actual stock returns of Delaware companies, which are affected by the bill, with the hypothetical returns of these companies estimated on the basis of certain standard statistical models, to see whether the actual stock returns are abnormally lower or higher than the expected returns. And our findings are very much consistent with the critics' concerns that SB 21 could be bad for investors. We find that around the date when SB 21 was announced, Delaware companies suffered abnormal negative returns relative to non-Delaware companies. And Delaware companies with more powerful shareholders, so with controlling shareholders or shareholders with large stakes or large voting power, performed worse than Delaware companies with weaker shareholders, even after controlling for a number of different characteristics, such as size, industry, and so on and so forth. So it seems that the stock market thought that SB 21 was bad for investors, and especially for investors in controlled companies.
Professor, as you just explained, your research methodology was based on a series of event studies. As you indicate in your paper, empirical evidence derived from the use of event studies has attracted significant criticism. Can you give us an overview of those criticisms and why you believe they're not relevant to your research findings on SB 21?
So the criticism you refer to, which we mentioned in the paper, is about the widespread use of event studies in securities litigation, where this methodology is employed by both plaintiffs and defendants to persuade the court that the contested statement made by the company did or did not affect the price or did or did not harm shareholders. There are a number of legitimate criticisms of the way event studies are sometimes used in lawsuits. It gets pretty technical, but if your listeners are interested, Professors Jill Fish and Jonah Gelbach have written a great paper on this topic, which I recommend to anyone interested. There are a number of problems, but these problems are typically problems affecting event studies concerning one single company, the defendant company in a securities class action. When you run an event study on a single company, your results can be affected by all kinds of random noise and assumption about statistical distribution of stock returns. Here, we run our analysis on about 2,000 companies, the 1,000 largest Delaware companies and the 1,000 largest US companies incorporated in other states. So the problems discussed in this literature are much, much less concerning. However, the intelligent consumer of empirical research, this is what I always tell students and others not acquainted with the details of this kind of methodologies, should always be a skeptical consumer. Just like any other empirical tool, event studies are helpful, but of course, corporate finance is an extremely complex social institutional phenomenon. No single tool can get to the truth of it. If someone claims they found the truth, you should not believe it. It is a useful tool, very useful, we believe, to get a sense of what market players thought of a certain event like SB 21. And since everyone talking about this bill, both critics and supporters, they argue that their favored regime, whether pre or post the reform, is better for investors. We think it's very important to actually take a look at what investors thought of the news of the new bill, how they reacted with their money. And this is what our event study shows.
Professor, can you give us some more color on your research findings with respect to Delaware companies with dual class stock structures, which are of a particular interest to corporate governance experts?
Well, in dual class structures, as your listeners know, founders or family members with a minority equity stake have a disproportionately larger voting power. For example, in Meta, Mark Zuckerberg, I did the math the other day, owns, I think, a bit less than 14% of the shares, 1/4, but has 61% of the votes. That's what a dual class structure does. So there are two interesting aspects of dual class companies that are relevant for SB 21. One is that dual class companies, of course, typically have powerful shareholders. Many of them are controlling shareholders like Zuckerberg, and some may or may not be technically controlling shareholders, but have very substantial size of voting power. Therefore, if critics of SB 21 are right, we should expect the stock returns of dual class companies to be abnormally worse than the returns of single class companies within Delaware. And this is precisely what we find. So the market seems to believe that SB 21 is particularly bad for investors in dual class companies. It is bad for all investors in Delaware companies. That's what the data tell us, but even worse for investors in dual class companies. Another interesting aspect of dual class companies, which is a bit more complicated but interesting, is that dual class controllers have weaker incentives than single class controllers to do what's good for investors. And the reason is that dual class controllers have less skin in the game. If we compare to controllers with the same voting power, say the 61% like Zuckerberg, the single class controller with 61% votes has 61% of the shares at stake. But Zuckerberg has only 14% at stake. So his incentives to increase shareholder value are much, much weaker. So this means that SB 21 should be worse for dual class companies, even keeping the voting power of the main shareholder constant. In a blog post in the Harvard Forum on Corporate Governance, Professors Lucian Bebchuk, Hobby Castiel, and Ed Rock made this point in a very clear way, and invite your listeners to take a look at the post. Here, our findings are less robust than our other findings, but we do see some indication in this direction that dual class companies fared even worse than single class companies with similar shareholders with similar voting powers. Regardless of these details, however, it's pretty clear from our data that the stock price of dual class companies reacted much worse than that of single class companies.
Professor, final question. The Delaware Supreme Court currently has before it constitutional challenges to the validity of SB 21. Can you explain to our listeners the constitutional issues that the Delaware Supreme Court will be considering, and give us your prediction on how the court will rule on those issues and how the ruling will impact, if at all, the future of SB 21?
One of the things that the new statute does is to say explicitly that if the board follows the new simplified safe harbor procedure, the courts may not provide equitable relief. So equity plays a very important role in Delaware corporate law. U.S. law inherited the concept from English law, but the very idea goes back to Greek philosopher Aristotle. The basic idea is that rules are a very imperfect tool. Often courts are faced with complicated situations that do not exactly fit the rule. So they need to get a bit more creative to achieve a fair outcome. This is very, very roughly what equity is about. My colleague and expert of equity, Henry Smith, has written that equity is a safety valve. When general rules get to unpredictable and wrong results, equity fixes the problem. But equity means trusting the court to fix the problem. And the message from the Delaware legislature in ruling out equitable remedies here is a pretty clear message. They say we do not trust our courts. This is not a great look, of course, for the Delaware system. But whatever we think about whether this is good or bad policy, there is a potential constitutional issue. In 1792, the Delaware Constitution gave the Court of Chancery the power to administer the remedies and principles of equity. And there is a precedent, DuPont v. DuPont in 1951, where the Delaware Supreme Court said that the state legislature cannot take away this power from the Court of Chancery. So this is why there is a constitutional challenge going on, because the lawyers promoting this challenge are saying that SB 21 violates the Delaware Constitution by stripping the Delaware courts of their equitable power. And the Delaware Supreme Court will have to make a decision on this. I'm not an expert of Delaware constitutional law, so I will not make a prediction. But regardless of the constitutional interpretation issue, there is a complicated political issue here. The political message from the legislature and the governor incorporated in SB 21 is we don't like what the Chancery Court has been doing recently with respect to controlling shareholder conflicts. Does the Delaware Supreme Court have the political capital and political will to fight back by striking down the statute as unconstitutional? I mean, maybe there are compromise solutions. that are more palatable politically. We'll see what happens.
That concludes our podcast episode. On behalf of the Council of Institutional Investors, I want to thank my special guest, Roberto Tallarita, Assistant Professor of Law at Harvard Law School. If you have any questions or comments regarding this podcast, please feel free to contact me at Jeff, that's JEFF, at CII.org. Until next time, I'm Jeff Mahoney. Thanks again for listening to the Voice of Corporate Governance.
Thank you for listening to this episode of The Voice of Corporate Governance, brought to you by the Council of Institutional Investors. The Voice of Corporate Governance is a free, non-sponsored podcast that highlights critical developments in corporate governance and other important issues affecting institutional investors. The views expressed by those interviewed on the podcast do not necessarily reflect the views of CII or its members. For more information on CII and its policies on corporate governance, please visit our website at www.cii.org.